Do you know what a preliminary hearing is? We're going to talk about that in this and a couple of other videos. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. If you've been accused of a felony crime in California, you've probably heard the phrase preliminary hearing thrown around a few times. You might have been asked at your first court date, do you waive time for your preliminary hearing? You might have spoken to a couple of attorneys in terms of what they would charge for representation, and they might say, this fee covers everything through a preliminary hearing. You might also hear people talk about the preliminary hearing, in court, where they might call it the preliminary or the prelim. But what is a preliminary hearing, and what is really the game plan for your preliminary hearing? Well, at a preliminary hearing, the prosecution has to prove to the judge that there is what's called probable or sufficient cause that a crime was committed and that you committed the crime. This is a very low burden to prove, and more often than not, the prosecution meets it. However, by virtue of forcing the prosecution to do this presentation, they open their witnesses up to open questioning so that you can cross-examine them. You can develop a strategy for later trial and negotiations, and you can also maybe get some charges reduced or even dismissed. I'm going to try to break this down in a couple of videos in this series that explain some general strategies that I picked up on for defense at a preliminary hearing. And hopefully, if you're watching these videos, you have a better sense of what to expect going forward in defending a felony case in California.